On Tuesday, the Senate Judiciary Committee held a hearing on Section 702 of the Foreign Intelligence Surveillance Act, also known as FISA, a very powerful tool the government has used since it was passed into law in 2008 that allows them to surveil foreign individuals outside the U.S. and it requires phone companies and internet service providers to give them email, phone, and text records of the individuals targeted. However, a number of senators during the hearing said they continue to be concerned that average Americans on the other end of these phone calls, emails, and texts are being caught up in this eavesdropping, and that government agencies like the FBI, DOJ, and CIA have used their information improperly. Joining me to discuss this is Patrick Eddington, Senior Fellow in Homeland Security and Civil Liberties at the Cato Institute. Patrick, thank you so much for joining me today.
My pleasure.
So I briefly touched on just a second ago what Section 702 of FISA is, but can you fill in any gaps that I may have missed? Obviously, there's probably more to it than what I just mentioned. And how important this law is, how reliant these government agencies are on it.
I think, giving our viewers and our listeners, a little bit of history here is actually quite important because this particular authority began life in sin, so to speak, 2 days after the 9/11 attacks, when he was director of the National Security Agency. General Michael Hayden ordered NSA to go ahead and begin monitoring phone traffic, essentially originating from Afghanistan. And within 2 weeks of that, he had broadened it to any kind of communications between Afghanistan and the United States. Now, the problem with that, of course, is that anybody who had loved ones overseas, who was an American citizen, their communications were automatically going to get caught up on that. So what happened was this all began essentially as a top secret program that then President George W. Bush wound up essentially reauthorizing repeatedly over the next several years. And it wasn't until December of 2005 that the New York Times actually exposed this program. Its code name was Stellar Wind. And that began at that point a 2.5 year battle in Congress to try to take this illegal and unconstitutional program and make it at least nominally legal. And that's how we got to the FISA Amendments Act, Section 702. To get to the other aspect of your question, I don't think there's any question that the FBI, NSA, the Office of the Director of National Intelligence, the Secretary of State, all believe that this program is providing them with information that is of value. It's important to remember, though, that the original justification for this program was counterterrorism. And that's not really what they're doing right now. That's not how they're selling it. And at that Senate Judiciary Committee hearing that you referenced, a number of those folks from the federal government on the executive branch side really played up the utility of FISA Section 702 in detecting fentanyl trafficking, right? So this is just another way that they've essentially kind of moved the goalpost about, exactly how this program can or otherwise should be used. And then one final note, and I think this is critical. Up until just this past year, this program had been so badly abused by the Federal Bureau of Investigation that they had conducted literally millions, I should say, of so-called backdoor query searches. And what I mean by that is when this data is collected from the telecom companies, it goes into databases at NSA. And there that data is literally raw. So no names have been redacted, none of that kind of stuff. And so you had FBI agents going in there and conducting literally millions of searches without any kind of probable cause, and thus, no warrant signed by a federal judge to do it. And that's really one of the key things that I and others believe absolutely has to change here with respect to this law. And a lot of senators and members of the House of Representatives feel exactly the same way.
And I want to get into more of that in just a second, but is this law being used in the way it was intended? And in those circumstances, in terms of fighting terror, is it something that's useful? Like, is it something that these agencies do need and need to figure out a way to use properly?
So I think the critical thing to remember here is that the 9/11 attacks, which were mounted, of course, by Salafist terrorists and specifically Al-Qaeda, those attacks did not succeed because our government didn't have the information. Our government had the information. They simply failed to put it all together. And I think the biggest problem with this particular program is the mass surveillance aspect of it is not only ultimately violative of Americans' rights when there's no requirement that they get a warrant from a judge to search any kind of stored data on Americans, but it also just puts a lot of junk into the system. You're talking, terabytes and terabytes of data at the end of the day, and storing all of that, most of which is completely useless, no real intelligence value at all, just serves to basically gum up the works, from an intelligence standpoint. And as a former intelligence officer, I will tell you that the very best in terms of law enforcement and intelligence work comes when you have very specific information. And there are plenty of examples of that. But to kind of get directly to your point, executive branch officials have claimed that this particular program has been successful in thwarting at least a few terrorist attacks on the United States. The Zazi case is the one that the Privacy and Civil Liberties Oversight Board talked about in their report almost 10 years ago. But there just haven't been that many at this stage of the game that they've really remotely kind of referenced publicly. What they've talked about a lot more are these other uses that the particular information has been put to. And I think, when you hear some of these folks from FBI, NSA, and the like claim that if this authority goes away, they'll essentially go dark, that's false. What they get right now essentially is compelled compliance from the telecom providers, AT&T, Verizon, and so on and so forth. But the reality is the president of the United States, if this particular law was to lapse, could sign a presidential finding in secret authorizing NSA and CIA to go ahead and simply tap into these systems covertly. They could also authorize them to actively recruit people and the FBI to actively recruit people who work at these organizations. Alternatively, they could work out a deal because there's really nothing from a statutory standpoint that would prevent this. They could work out a deal to simply pay the telecom companies for this kind of information. So at the end of the day, we need a probable cause-based warrant requirement for them to access U.S. person data. I don't care if it's in physical form or digital form. And hopefully that is one of the key changes that we'll see this year.
We'll talk a little bit more about that. Some of the oversight that senators and people like yourself are seeking, because this isn't just from my understanding, this is not simply a partisan issue. It seems as though members from both sides of the aisle have reservations about how this system is being used. What kinds of things, if you can elaborate a little bit more on what kinds of things can be put in place in order to make this a more lawful, a more useful tool?
Look, I mean, the straightforward solution, if we're going to allow them to continue to collect this data, to me, there are two key things that have to change. First, if they want to access, and I mean, look at actual content, like of a text message or an email or anything else, of an American citizen, they should be forced to abide by the Fourth Amendment, which clearly states that no warrant shall issue except on the basis of probable cause. And we're talking about, one person, one warrant essentially here is how this really ought to be basically working. That's normally how it works in every other, Title III domestic context. And then I think the second thing that we have to have here is essentially mandatory database purges here. So in other words, if they collect information that's of absolutely no intelligence or criminal law enforcement value, they shouldn't be allowed to sit on it and maintain it indefinitely, if it's U.S. person data. Right now, they assert the right to basically keep this stuff for 5 years. If there is no actual nexus to a hostile foreign power, someone acting as, let's say, an agent of a foreign power or agent of a criminal cartel, terrorist organization, that data should be purged. It just simply should not be there. And we would need back-end checks on that by an independent auditing authority. My preference would be the Government Accountability Office, Congress's watchdog. But it's possible that the Department of Justice Inspector General and possibly NSA's Inspector General could do that. I'd prefer to have GAO do it, quite frankly. I'd feel more confident. But for me, those are the two minimum things. But I think what's really important to also kind of emphasize to anybody who's listening or watching this is this. Our problem goes way, way, way deeper than one authority here in terms of FISA Section 702. When the Patriot Act was passed in late October 2001, this is, of course, a provision that has over 150 different specific titles within it. 16 of those provisions had so-called sunset provisions or expiration dates. And today that number is 0. So there's literally an entire generation of Americans who have grown up essentially under this surveillance state, under this, virtually dystopian, Orwellian, kind of country in that regard. And that has a fundamental warping effect, I believe, on our society and certainly on the entire concept of the rule of law and individual rights. So we need to have a fundamental reexamination. It's been almost 50 years since the late Senator Frank Church of Idaho led what was then the most comprehensive investigation of the U.S. intelligence community to date, the so-called Church Committee. And we're long overdue for something like that again, because the number of surveillance authorities that have been either directly passed by Congress or simply implemented by the executive branch unilaterally since the 9/11 attacks, I think most people would probably be kind of staggered if they knew how many of those were actually out there and running.
Well, does the CIA, the FBI, and the DOJ do they admit that there has been some wrongdoing, or that this law has been used, this thing that they have at their disposal has been used improperly?
Reluctantly, and in every case, they claim that they have made changes. And I think the important thing to remember on that particular point is that we have seen these violations take place virtually since the day this program was started. That's almost 15 years ago. And the problem that I have, and I think a lot of people who work constitutional law and privacy and civil liberties issues have, is that the Foreign Intelligence Surveillance Court, which is supposed to basically be the body here that prevents this kind of stuff from happening, has more often than not simply served as a rubber stamp. And when they have actually called out FBI and NSA, for violating their court orders, nobody has been sanctioned and nobody has lost their job. And that's a complete breakdown of the rule of law as far as I'm concerned. And it's basically telling the agencies, you can come before the court, you can lie to us, we'll just slap you on the wrist, or we'll just use harsh language with you, but you can go on with business as usual. And that's why we need a congressional intervention here. And I think, as you indicated, there are folks on both sides of the aisle who do recognize that.
And just to kind of piggyback on that point, do you get the sense that the motivation in Congress is there? It's hard to get these guys to agree on much of anything with the polarized nature of Republicans and Democrats in Congress. But do you anticipate Congress coming together with some new rules, some new oversight, or do you anticipate this program sunsetting?
I see no possibility whatsoever that this program goes away. You have too many surveillance hawks, too many national security hawks, people like Tom Cotton of Arkansas and others who really absolutely want to see this program continue. But even they, I think, at this point will admit that the level of abuse, the frequency of it, the scope of it has been such that a bona fide congressional intervention here to at least require a probable cause based warrant to access U.S. person data is the bare minimum that ought to happen. I've been telling every office on the Hill that I've been meeting with over the course of the last 6 months that if you just reform 702 and you just check the box and you think that's it, you're going to be very sorely mistaken, because a lot more of these kinds of scandals are absolutely going to surface as we go forward. And that's why a much more forensic examination of this is in order. And I want to give credit to Representative Nancy Mace, Republican of South Carolina, and Representative Jamie Raskin, Democrat of Maryland. Early last year, they asked the GAO, the Government Accountability Office, Congress's watchdog, to begin investigating the FBI's misuse of these things called assessments. And these are, of course, essentially a tool that the FBI can use to open an investigation on you, me, and organization with absolutely no criminal predicate whatsoever. And here at Cato, as part of our Freedom of Information Act program, we discovered a couple of years ago that the FBI had targeted Concerned Women for America, a venerable, highly respected pro-life organization, essentially for a so-called charity assessment, trying to basically, find out whether or not there was any kind of financial wrongdoing. And they opened that particular assessment with absolutely no criminal predicate. Nobody had come to the FBI to say that anybody at Concerned Women for America was engaged in any kind of financial impropriety. And it's those kinds of abuses, I think, that our viewers and listeners really ought to be very, very concerned about, because the problem is much more widespread. And I should say that Cato has been in court for years now, litigating Freedom of Information Act lawsuits to try to pry open as much of this kind of information as possible so people get a much better sense of just exactly how big the problem is.
Last question for you. Perhaps reading the writing on the wall, do these agencies, are they taking any actions on their own that move the ball down the field at all to try to mitigate Congress's involvement, or to try to police themselves in a way that they haven't thus far?
The FBI has claimed that they have made additional changes to how their databases operate in order to make it far, far more difficult or create an additional series of internal hurdles for folks to access this stuff, without actual real good cause. And that's all well and good. But they said that before. I mean, in fact, they said that every single time that the FISA court called them out for previous violations. So, again, this is where we need absolute bona fide external congressional oversight and an actual change to the statute to ensure that it is truly compliant with the Fourth Amendment, because right now, for all intents and purposes, it truly is not.
Well, it's something we'll be keeping an eye on over these next few months because this program is set to go away at the end of the year unless it's reauthorized or unless Congress intervenes. So we'll see what happens as both sides of the aisle, lawmakers on both sides of the aisle and in the House and Senate. I know there's a House working group that's looking at this situation as well. So we'll see how it all shakes out. And we'll be making sure to follow everything you're doing, Patrick, over at the Cato Institute. If people want to read your writing or anything that you're working on, how do they do that?
Simply go to the Cato website, www.cato.org. Click on the link that says experts. You can scroll down alphabetically. You'll find me there. You can just click on the link. It'll take you to my bio page, which includes everything in terms of what I've written, multimedia, the whole nine yards.
Great. Well, Patrick, I really appreciate your time. Thank you for joining me today.
My pleasure.